Good morning, Mr. Kiritsy.
May it please the Court, George Kiritsy, I represent the appellants Nancy and Cleveland Blair. This is an appeal from a judgment on the pleadings from the Worcester Superior Court. We would like to focus most of our argument today on the issue as to whether the Massachusetts Constitution, particularly Article 10, affords greater protections with citizens than does the United States Constitution generally. We start with the caveat that although government may regulate property, if the regulation goes too far, it will be recognized as a taking. Federal and Massachusetts courts have developed guidance to determine how far is too far. They have defined two species of categorical or per se takings. The first species of a per se taking is the physical invasion case. The second species of categorical taking is when government action deprives an owner of all economically beneficial use of the property. Or as
That's regulatory, right?
That would be regulatory.
Yeah. Now, just in terms of the overview, Article 10 was written long before. They didn't have regulatory takings when Article 10 was written, did they?
Generally not, Your Honor.
Well, what do you mean generally? Didn't Judge Agnes point out that the relied upon language of Article 10 was written 142 years before the plaintiff's legal claim was even recognized?
That would rely on the fact that the Pennsylvania coal case, was in truly the first regulatory takings case. The Commonwealth argues, and Judge Agnes agreed, that taking at the time the Constitution was drafted meant only physical seizures. In essence, they would recognize, or they would have this court recognize, that only the first species of categorical takings applied back in 1780. But it ignores the historical context of the Massachusetts Constitution. In 1774, the British Parliament passed the Boston Port Act. That act did not seize 1 inch of property. It did not moor one ship at a Boston dock. It did not station one redcoat on a pier. Yet it simply told wharf owners they could not use their wharves. It told shore owners they could not use their shores. The law was non-seizing, but by everyone it was seen as a taking. And the common citizen believed it to be a taking. Ebenezer Baldwin called the statute a confiscation and said that it was a vote by Parliament to take away our landed property. John Adams, who drafted the Constitution, recalls in detail a conversation between Shrewsbury yeomen one night in December, where one yeoman says, if they can take away Mr. Hancock's wharf and Mr. Rowe's wharfs, then they can take away your barn and my house. These were contemporaries.
I take it, Mr. Kiritsy, that even in addition to the historical origins, there's no question that the regulatory takings are takings under the constitutional prohibition of takings, correct? So somebody, looking at the original intent of the document, has decided that a regulatory taking violates the Constitution, correct?
Well, certainly that was decided by this court in Boston Advertising in the early 1900s. It was decided additionally by Justice Holmes in the Pennsylvania coal case in 1922 that it was a taking, that if a government regulation goes too far, it will be recognized as a taking.
Well, it seems to me a little odd argument to say there was a taking. We conclude that there's a taking under the takings clause of the Constitution. It's a regulatory taking. It's a non-physical. But actually that wasn't around at the time of the takings, and therefore we shouldn't apply it now. It seems to me a little odd to look at it that way.
Your Honor, I believe that a non-alteration provision, an act by the Parliament or an act by the legislature that prohibited all alteration of property would have been preposterous to the people in 1780. Government was the Constitution limited government, and there was no way government would do that. In fact, I believe that's the reason why in the 1850s, in the Algiers case, this court stated that there is little occasion to impose any restraint on the absolute dominion of property owners regarding interior lands.
Let me assume that we agree with you, okay? That there's no original intent issue here. Why do you think Article 10 gives you more protection than the cognate provision under the federal Constitution.
Federal courts have historically, since 1978, stated that takings jurisprudence does not divide property into discrete segments.
I understand what the difference, but why do you think Article 10 gives you greater protection?
Because Article 10 is an express prohibition against the taking of any part of property. It seems illogical to require a Massachusetts judge, which is what under the federal jurisprudence, require a Massachusetts judge to determine that all the property has been taken before she can determine whether or not any part has been taken. Massachusetts Article 10 must provide greater protections if the federal Constitution or if the Fifth Amendment is in fact all or nothing. Massachusetts, which has an express prohibition against the taking of any part, has to provide greater protections.
So there's always a taking whenever there's a regulation that says you can't do something on a portion of your land. So you can't build something next to a marsh, even though the strip may be 10 feet and your land may be 5 or 6 acres. That's a taking.
Your Honor, this begs the issue of the police power, and we always recognize the police power of the state. We start with the premise that government is charged with the power to regulate harmful uses of property.
Well, could I ask you about that, though? The Commonwealth says that what the record showed was that the runoff was going to come over the beach and the lawn or whatever, and pesticides from there would go into the water supply. So why couldn't one look at that as legitimate regulatory action that's trying to deal with harmful consequences of your use of your property? Or your
this is one of the places where the Watershed Protection Act fails. Exactly. It doesn't distinguish between harmful uses and benign uses. It prohibits all alterations. One can't build a flagpole or a shed or a flower garden.
On the record in this case,
in this case, you can't build a lawn. The Commonwealth, the application for the variance is for the lawn. But if fertilizers or pesticides were the harmful uses, then it is the duty of the Commonwealth to restrict those, but not every use. They must prohibit the harmful uses, but not the lawn. We note that the MDC itself maintains a lawn on the banks of the Quabbin and the Wachusett reservoirs, and a lawn has been determined to be the most benign of uses.
But I had thought that you were not contesting that there's a rational basis both for the law and for its application in this case. Your
Honor, the issue of legitimate state interest or a rational basis, that's no longer plays a role, as the Gove case noted.
Okay, so you're saying that's not the issue here. The issue is they had a rational basis for it, but it constituted a taking.
I beg your pardon?
I gather your argument is that they had a rational basis for doing what they did. You may disagree with it, but you agree it's a rational basis, but that it constitutes a taking under our Constitution.
That they have a rational basis to regulate that areas, Your Honor, but they must do, but their regulations go too far, and that's what
well, but now you've confused me, because it's one thing to say that they don't have the power to regulate versus they do have the power to regulate, but when they exercise that regulatory power, that constitutes a taking. Which one is your argument?
My argument is that they have the power to regulate. They may regulate to prevent harmful uses, or they may regulate to provide for beneficial uses, provided that benefit is spread out among all the citizens. But when it comes to regulating harmful uses, they must regulate only the harmful uses, not all uses. So they must regulate the elimination of fertilizers and pesticides, not the lawn. The lawn itself is not a harmful use, and there was no finding that there was the case. Mr. Poole's testimony is that fertilizers and road runoff would reach the waters, but it doesn't say that the lawn would cause any harmful use. So it is incumbent upon, it is a difficult job to be a legislator. The legislature must act responsibly. They must protect water interest and clean water, but they must do so as to protect private property. If we are a constitutional democracy, then the Constitution states the limits by which government may act. It says, thus far ye shall go and no further. And in this case, the government has gone out and with a broad sweep of a pen eliminated all alterations in this over this property. And this is not a case, Your Honor, relative to...
I thought they had only barred the alterations which your client had done. They didn't, I'm not aware of them saying that you may make no alterations, just not the type that your client, in fact, carried out.
No, not carried out, Your Honor, applied for. We applied for a variance. The variance was denied.
denied. Okay.
And we requested permission to put in a lawn. The lawn itself was as I said, was a benign use. But one of the points that's necessary to note about the Watershed Protection Act is that it is not a global act. It doesn't affect all watersheds, doesn't affect all wetlands, doesn't affect all drinking supplies. It was designed for one purpose, and that was to protect the Boston drinking supply only. It doesn't affect lands in Boston, doesn't affect Cape Cod or the islands, or the north or south shores, or lands south of Worcester, or lands out in the western part of the state. Only north central Massachusetts. And this is important because this act is only about money.
Mr. Kiritsy, can I just interrupt you? As I'm listening to your argument, it sounds to me, and following up on Justice Gans, that you are making an argument that this is beyond the police powers. It doesn't go to the health, safety, and welfare. We're a government that is limited, and our police powers are limited. That's what this argument sounds like to me, rather than a takings argument.
Your Honor, regulations are defended on the police power. That if the
No,
regulation
I
goes
understand that.
too far, then it violates, then it exceeds the police power. And that's exactly what we're arguing. That this regulation, that the denial of this variance exceeded the police power of the Commonwealth.
And therefore became a taking?
And therefore became a taking.
Are there cases? There are cases, I know, that say that this is beyond the police power. In other words, we look to the welfare, the health, welfare, and safety of the citizens, in essence, defines the appropriate use of the police power. Are there cases that say where an act of a legislative body goes beyond the appropriate use of the police power, that turns it into a taking?
That I believe is the fundamental premise of Pennsylvania Coal, that government may regulate property uses, but if the regulation goes too far, it will be recognized as a taking.
I thought the fundamental premise of Pennsylvania Coal was that, and maybe we're just seeing the same case a little differently, was that the excessive, if I may say, regulation in effect diminishes or may obliterate the value of the property such that it constitutes a taking, not that it is an excessive, it's beyond the appropriate use of the police powers.
Value alone, value is one determinant, but it is not all.
No, I understand that. I understand that.
If a regulation destroys all value, then it may be considered a taking. If regulation destroys
Except that if it exceeds the police power of the state, if the action exceeds the police power of the state, it's void, isn't it? You don't get money for it. You don't get compensation. You get a declaration that this alleged taking is void.
That's what this case is, Your Honor. This is not an inverse condemnation case. It's an action to declare that the act is void. Boston Advertising in 1905, that was the exact conclusion, that under Article 10, that the removal of one of those sticks in that bundle of rights rendered, without a compensation element, rendered that act void. I'll note, Your Honor, that in the McGibbon case versus Duxbury, this court took up an issue. It's not in my brief, Your Honor, but this court took up an issue with a zoning bylaw that contained a complete anti-alteration provision of wetlands in certain waterlands. And this court said that, no, that exceeds Article 10. That exceeds, at that time, that was pre-Pennsylvania Coal. That was before Penn Central. That exceeds the constitutional protections that an act by a local zoning board or by a town to restrict all uses of property on a particular piece of property was void.
But this has a provision for a variance, so you may disagree about whether you should or shouldn't have gotten one, but it's different than Duxbury.
No, I believe in Duxbury, Your Honor, that there was a petition, there was a variance procedure. He was denied that, and so that was, I believe, there was a variance procedure in the Duxbury case. The existence of a variance is not alone determinative. There was a variance procedure in Lucas that the Supreme Court still found, where the Supreme Court still found it taking. And I would note the difference between a variance procedure and a permitting procedure. Whereas a permitting procedure presupposes that the use is allowed. The default setting is to grant the use, but then restrict it or to give reasonable conditions so that it is not harmful. The variance procedure defaults to say deny. And then only in cases of extreme hardship should we allow the use to be granted. Your Honor, I haven't touched upon the issue of Article 49, but
And I'm afraid, Mr. Kiritsy, that you're going to have to rely on your very well-written brief.
Thank you, Your Honor.
Good morning, Mr. Schofield.
Thank you, Your Honor. And may it please the Court. It is a fundamental principle of our system of government that the government may regulate private property use in the public interest. And in doing so, it may deprive a property owner of a beneficial use, even the most beneficial use, without the regulation affecting a taking.
But can the government essentially apply someone's land to the public use without compensation? I mean, isn't this a question of applying it? Aren't you essentially saying, no, you've got to put trees back up, you have to maintain trees, you have to do all of these things for the public benefit? Isn't that applying the land
There are
for public use?
several answers to that question. The first is that's an argument raised in the Blair's reply brief. It was not raised below. It was not raised in their opening brief, and it's there.
I'm just reading the language of the Constitution.
Oh, sorry, Your Honor. I thought you picked up.
Excuse me.
Yes, but the merits-based response to that is that the Commonwealth is not, in fact, applying the Blair's use to property to a public use. The Blair's would still retain ownership of the property. They still maintain the sole right to use the property for recreation, camping. They can use the beach and lawn that they already have, which, by the way, was authorized under the Watershed Protection Act and under the exceptions. And they have the right to keep the public off their property. So the Commonwealth is not, in fact, applying their property to public use. What it's doing...
But I'm sorry to interrupt you, but just picking up on Justice Cordy's question, Article 10 talks about no property can be taken, and then it also says, or applied. So there's a difference between a taking and an application. I'm positing that question to you. And if there is a difference, then a taking, as we commonly understand it, is a taking that leaves a property with absolutely no economic value to the owner, or if it's applied to public use, it may suggest, Article 10 may suggest that something short of a taking, that some application of the property to public use by the government warrants compensation.
The Commonwealth, the DCR, would disagree with that position. Again, it's not in the briefs because...
Well, then what does application mean? What does or applied mean?
Or applied, the basis for that, and going back to the original understanding, was that the framers of Article 10, and for 100 years afterwards, people understood Article 10 only to apply to the physical confiscation of property. Now, the as-applied piece of Article 10 deals with a situation in times of war, I believe, when government would come in and actually take a part of a person's property, such as their field, and take the food and apply it to a public use by taking it and using it to feed soldiers, or taking the horses and using it to pull wagons for weapons.
So here they're taking a portion of Mr. Kiritsy's client's land, and they're restricting his ability to use it so that there won't be any runoff into the public water supply. I mean, he still owns it, but there are a lot of things he can't do on it anymore.
Well, he can do everything he wants with his property right now. What he wants is...
Can he not put up the trees?
Excuse me?
Can he not put up those trees?
He Can he not put up the trees?
Yeah,
Can he cut down more trees, put it that way?
Can he, under the Act sets forth, it's carefully balanced. It allows property owners who have a lot pre-existing the statute to build a house or reconstruct an existing structure. The Blairs took advantage of that. They built a nice single-family home, a 3-car garage. They have a driveway.
No, I understand, but can they just chop down all the trees on their property?
No, they cannot chop down all the trees on their property. They can chop down a certain amount of them, but they cannot go so far as to have an impact on water quality. And in this case, the department found...
So now we go to Article 49. Don't we have to pay for that? Isn't that what 49 says?
No, Your Honor, that's not what Article 49 says. Article 49 is an environmental rights provision, and what it does, it's two things, and the debates demonstrate this. The reason for that was there was some concern that the government actually physically taking property was not considered a public purpose, and therefore would not comply with the public use provision in Article 10. So they passed that. Article 49 did not contain... In 1972, Article 49 was amended or annulled by Amendment Article 97, and that retained the environmental rights provisions, but also authorized the Commonwealth to purchase property and authorized the legislature to pass legislation to protect those rights. There's nothing in Amendment Article 97 that requires compensation. It does not, in fact, establish an independent right to compensation that's different from or in addition to what's provided in Article 10.
Mr. Schofield, do you say that Article 10 applies to regulatory takings?
I think the Commonwealth would concede that there are certain circumstances, and it's been developed over time and upheld by this court, that there are circumstances where a regulation may go too far and may, in fact, become the functional equivalent of an actual physical confiscation of private property for a public use. So yes, there are those situations. The question in this case is, how do you determine when the application of a regulation to restrict property use to promote public health and safety and environmental protection becomes the functional equivalent of a taking? Now, the Blairs are trying to shoehorn the terms "no part" into answering a different question, which is that when the taking occurs in the first place. Now, no part is, what that means is that if there is a taking, it answers the question of how much property may the Commonwealth take without providing compensation. The answer is none, no part. But that's a different issue from determining when a regulation, in fact, affects a taking. And in that context, the U.S. Supreme Court and this court, adopting those precedents, had said that the court has to look at the property as a whole. And that's important because it prevents property owners from manipulating their private property interest to essentially manufacture a takings claim.
Is it your view that our taking clause differs in any meaningful way from the federal constitutional taking clause?
I think that ours is different in that it makes explicit what is merely a little leaner in the federal clause.
Apart from clarity, in terms of substance, is ours different from the U.S. Constitution?
I think on this particular issue, how do you determine when a regulatory taking has occurred, and looking at the parcel as a whole, the answer is no, Your Honor. And I think this court...
What is your best case for that? That is to say, what is the case where we have been squarely presented with the explicit language of Article 10 as opposed to the more general language of the Fifth Amendment?
The closest case, Your Honor, is the Yankee Atomic Electric Company case, where it was a petition certification case dealing with a citizen petition that sought to restrict the use of our disposal of nuclear waste in the Commonwealth. It would have had potentially the impact of shutting down 2 nuclear power plants. Now, my understanding is that the plaintiffs in that case, the power companies, were arguing that there was a taking because it would have taken their part of their property, their ability to use that use their property to generate nuclear power. Now, there's two footnotes in that case that say, one, in the majority opinion, there's a footnote that significantly, it says in plain terms that the Commonwealth and the courts do not segregate and sever property interests for purposes of the takings clause, determining whether there's a regulatory takings. Now, the dissent written by then Justice Lynch also has a footnote which raises this issue that cites the no part language and says, well, the question might be a little different under our state constitution. And again, this was a state constitutional case, so our reading of that is that implicit in that majority opinion is that the court rejected that. Now, there's also some precedent from another state, which the Conservation Law Foundation cited in their brief. New Hampshire also has, and I believe it's the only other state that has this no part language in their constitution. In the case of, it's cited in CLF's brief, and it's Quirk v. New Boston. It's a 1995 decision. The New Hampshire Supreme Court was presented with this same issue, whether the plaintiffs in that case, the claimants in that case, were making a similar argument that the court should look at, as a matter of state constitutional law, only the affected portion of the property. And in that case, it was a campground, and the municipality passed a zoning ordinance that created buffer zones around campgrounds. It's kind of similar in this case, except the buffer zone in here is to protect a source of drinking water. And the court rejected that argument, saying we don't focus only on the affected part of the property to determine whether there's a taking, because that disaggregates essentially the expectations of the property owner is. That the court has to look at the property as a whole to determine whether it's become the impact of the regulation has become the functional equivalent of a taking.
If an entity owns land on both sides of a street, either side of a street, and acquired it and has a little shopping mall on both sides of this street, and there's one restaurant that services these shopping the shops, and the person who developed this acquired maybe 5 or 6 parcels, put it all together, and then created this little shopping center package with one restaurant. And the state comes in and says, geez, we need to take this land, a portion of this land. It turns out to be the restaurant. Do we take into consideration the effect that the loss of that restaurant has on the entire shopping center, which has been operating, say, for 10 years, even though it came together from 7 or 8 different parcels of land? Or do we only consider the land on one side of the street? Or do we only consider the parcel in which the land on which the restaurant was acquired?
As I understand your question, the government is actually coming in and physically taking the property?
Yeah.
Well, in that case, that would be an eminent domain case, and the Commonwealth would be required to compensate the property owner under Article 10 and the federal Constitution. That's essentially.
But what's the relevant parcel?
Well, in a physical takings case, you don't look at the relevant parcel. You do because the property has actually been physically taken, and the Constitution mandates compensation in that situation. That's a good case to look at for that is the U.S. Supreme Court's decision in Loretto, which dealt with the putting cable boxes on private property, and the court said that actual placement of the cable wires in the box, and they're just small pieces, that was an actual physical occupation of the building, and that required compensation under the takings clause. And we think that take the same position under the state takings clause, that when there's a physical occupation, when the government has actually taken property, there's no question about what was taken or if it was taken, and compensation is required. But it's a different issue when government passes a regulation that restricts a use of property, and the landowner essentially maintains possession of their whole bundle of rights. The physical possession, they have temporal acquisition, and they also have vertical acquisition. For example, under the Blair's interpretation, ordinary and commonly well-accepted regulations such as setback requirements would all of a sudden become takings under their analysis because the local ordinance would have taken a part of their property, or height restrictions or lot size requirements, a whole host of ordinary and well-accepted community and environmental protections would become takings under their analysis. And I think that in Giovanella, although the court was dealing with the federal takings clause, the court warned that adopting an affected part standard would practically ensure compensation for every regulatory imposition. That's at page 731 in footnote 4. Now, the distinction between the physical and the regulatory takings is thus found in the text of the Constitution itself. Its plain language requires compensation when the government physically takes property, but there's no comparable reference to regulations that affect a use of property. And the U.S. Supreme Court in the Lake Tahoe decision conducted a similar analysis where Justice Stevens distinguished between these two interests. In summary, Your Honor, the regulation of private property is ubiquitous. Abandoning the parcel as a whole test as a matter of state law would lead to a flood of cases challenging everyday public health, safety, and environmental regulations. The court should retain the parcel as a whole test as a matter of state law and thereby maintain stability and coherence in Massachusetts takings law. Thank you, Your Honor.
Thank you, Mr. Schofield.